Hello and welcome to Niaga Spotlight with me, Tamina Kauschi. Niaga Spotlight goes through the week in business and future affairs, market watch, industries, analysis and insights. We've got you covered right here on Niaga Spotlight. Well, this week on analysis, we look at legal updates and enterprise impacts. Now, in the most recent World Bank annual Ease of Doing Business report, Malaysia ranked 12th globally and second in East Asia and Pacific region, demonstrating its favorable business environment. Malaysia upholds business-friendly policies that are pragmatic and effective, cultivating a stable and supportive environment for businesses to thrive. In addition to a healthy business environment, Malaysia remains one of the fastest-growing economies in Southeast Asia. Our business-friendly benefits include low corporate tax rates, plus amendments to legislation affecting companies, and an educated, fairly competitively priced labor. This discussion today focuses on 2023's key legal updates and their implication and impacts for businesses and enterprise in Malaysia. Kokila Vaani Vadiveloo, Selangor Bar representative to Bar Council, joins us now in the studios for this discussion. Kokila, good morning. How are you today?
Good morning, Tamina. How are you?
Fantastic. So, Kokila, let's get this very interesting discussion started off by looking at what the general conditions are like from a overarching legal framework and that perspective when it comes to Malaysia's open market economy, also having a business-friendly policy framework. Do you agree with that statement?
Definitely. I think Malaysia has done very well. I think the fact that we are actually looking into many one-stop centers, that is something that many people do not know about, but it has been mushrooming. It's something that how I feel Malaysia has actually opened up this open market in terms of letting people actually get access to doing their business in any way possible to make it more accessible and easy for them. I think many people don't realize it, but it's also something that has been recently done after COVID. There's a lot of legal statutory delays that was actually recognized by the law, was amended
exactly.
to allow.
And you were very active during that time frame, I do recall. So what were some of the gaps that were really identified, especially by the legal fraternity when it came to ease of doing business?
I think there was a stop actually from winding up petitions. That means the companies were not allowed to basically become wound up by any of the creditors. And I thought that was a very good law because during the COVID, we all realized there was a huge delay and we know that the businesses could not go on, could not operate as usual.
They could not be nimble as well,
that's
responding to extended lockdowns and such like.
That's right. It was a very uncertain time. So when we have winding up, and for individuals, we had the bankruptcy laws that was also put a stop in the courts. There was no bankruptcy hearings or winding up petitions actually heard. And that actually gave companies or businesses a huge leeway to continue operating, hoping to see the light at the end of the tunnel, I think. So I feel that that was one of the best laws that actually came up during COVID when they put a stop measure on winding up petitions. So companies could still be there despite having creditors breathing down their neck.
Exactly, because they were given that allowance, given the extenuating circumstances. Kokila, I'd also like to go a little bit into the advantages we currently are actually seeing in Malaysia specifically for more digitized businesses.
That's right. Actually, I was coming to that, Tamina. Well done on the question. I feel that, if you look at it now, to register a business, let's go back to basics.
Sure.
I think people do not see the basics. I think the basics is the SSM now, the company search. You can actually register your business online.
Sure, you don't even have to physically be present.
That's right.
Anymore.
And even permits or licenses that you acquire for your certain type of businesses, it all be streamlined into online now. So all you have to do is just do it online and you will be able to get all the relevant approvals, the relevant permits, relevant licenses, and you will be able to actually start and operate a business by just actually logging in online and then registering online. It was never like this back then. So I think the digitalization, and it's not just that digitalization, I think it's also a lot of it were in terms of, I think another thing that I saw online was the fact that grants were given by all the relevant authorities, let it be MITI, let it be MIDA. You could see there was a lot of government grants that was actually given by these agencies. purely for businesses conducted online or purely with businesses having a little bit of access to online businesses or resources.
Exactly. And of course, as we're looking towards having the facilities for younger entrepreneurs and enterprise owners, I think that really makes a lot of sense. But when it comes to digitizing, right, of course, you then have to have the ability to sort of go online and be able to figure your way out.
That's right.
Have lawyers and the legal fraternity also played a role in actually facilitating this? Or is it something like basically you work in a silo and you get all your work done online itself?
I think initially it was tough, but I think the lawyers have already moved to, even in the courts, we've already moved to e-hearings and all that. And then
Correct.
we realized in certain states, especially in Selangor, for you to present your land titles or, you know, for purchasing house, we have this e-Tanah. So literally everything was online already. So it feels like we had to keep up with times. Of course, lawyers being an oldest profession, we always prefer the, you know, the
concrete
old-fashioned face, you know. But we realized that after that, we've also done a lot of Zoom meetings, even for first time, first time meeting clients. I think we have adopted, and the laws have also been amended to include hearings now by way of online. So I think lawyers have very much adapted to digitalization. Of course, with AI and ChatGPT, how are we taking it? I think it's still to be, I'm still old school. I think you still need to exercise caution when using this kind of stuff. But I think
still go through all your briefs as a process.
Definitely. Yeah. But it definitely speeds the process.
Sure.
It definitely does. And I think it is so much easier. You know, those days I remembered my clients who want to start up a business or even wanting to buy a property or even to buy over a business. It used to be that they used to come back and say, you know what, this document is not, apparently I need to relook at it. This was rejected. So can we look at this again? But now, with the fact that it's all submitted online,
sure,
they could actually get an update or notification on it just on that basis. So it's a lot easier, I think.
So definitely ease of processes. Great. So Kokila, moving along. Now, Malaysia's legal system also provides protection and enforcement of contractual rights that gives great certainty for business operations in general. Are there any sort of recent examples in particular that help to really showcase that this is what it is like on the ground for businesses and lawyers when you're working out?
Oh yeah, I think there were so many cases that we were, like, for example, one of it that I personally did was that the contractual ones were, of course, I think it all at the end of the day boils down to written agreements, right? But I think this court, they actually severed the clauses that was actually unfair for business owners, especially during COVID or even post-COVID.
Right.
And I thought that was very, very good. You know, I mean, of course, that decision was welcomed, but it was actually to realize that how important contractual documentation is in business sense. But at the same time, there's no need to be so fearful about it, because at the end of the day, if the clauses in your business contract with your contracting party does not make it's very unfavorable to a certain party or is very lopsided or one-sided, then I think you definitely can go to the courts and you will be able to see how this particular clause should be removed. And it will, at the end of the day, give the contracting party a fair level playing field in the area of business when it comes to disputes. Because at all written contractual disputes, there has to be, it can't be a unilateral view. It has to be both parties have benefited. There must be some consideration on both ends. In case, for example, if both of us are getting into a contract, there must be something that I'm getting in consideration of entering into this business with you.
Correct. So also I think it speaks of a wider need for awareness, perhaps even before signing these contractual agreements between businesses, right? And how do you think that level of awareness is, particularly for the newer enterprises that keep also, you know, mushrooming, but at the same time, not too many of them are sustainable. You know, making it past that hurdle of the first year in operations, how often is that actually connected to legal complications?
I think, okay, this is where we are stuck. I think what happened is at the heat of just doing a business.
Right.
I think at the COVID,
beginning operations.
Yeah, you know, they realized there was a certain businesses that was actually flourishing, a certain type, you know, like example, face mask, or like, you know, even all this
Basically personal care products.
Personal care products.
Hygiene products.
Sanitary, yes, you know, hand sanitizers and all that. It became such a huge thing. So a lot of people wanted to get into that business, but it all depends on the individual, whether they actually had a long-term plan of the sustainability of the business. I think we all know those who actually felt that the business who went in with the mind that this is a quick money, quick in 1 year, 2 year maximum.
Sure.
You know, and I think that's where it all fails, because you do not have a projection of it. Same, I think, goes to those who have actually just picked up a contract from the internet. Because of digitalization, it's so easy. Nobody actually consults lawyers or the relevant bodies anymore.
To make sure that that contract is relevant to you in the business.
Yeah. I remember, you would not believe it. I went to court and it was on this contract that both parties had signed.
Sure.
And it was shocking. And I think one of it had no clause of COVID, even though, you know, they just picked up a contract from a US-based company. And we must remember...
Always localize it.
Localize it, because, you know, the laws are very different.
Sure.
You can't just go and sign it just because you think, okay, I wanted this particular business because mine is for the purchase of gloves. So this is exactly what it is. And then you actually got, you know, you just signed it. So at that point, it was very difficult for the courts to decide, because you're like, what is this? You know, how do we go on from here? So I personally think awareness is there, but the fact of digitalization could be a good and a bad thing when you just rush into it.
Correct.
So they just picked up because they wanted the business to start. They felt that, and this is educated class I'm talking about. It's not those who actually feel like, okay, we lack in education. How do we start a business? It's going to be tough on us.
So looking for shortcuts sometimes does actually end up being a bit troublesome.
Yes, yes.
Point well taken. So from there, Kokila, let's quickly go through also the fact that Malaysia is also currently party to several FTAs, free trade agreements, right? That's actually, to enumerate it, 7 bilateral FTAs, 7 regional FTAs. But going past that wider socio-economic framework, let's go into what kind of legal implications do free trade agreements have, especially for local enterprises, particularly given the nature of FTAs, and have there been any examples of how these legal challenges can be overcome?
Yeah, I think many of them, actually, these free trade agreements, I feel that you need to be able to find a fair resolution between parties when there's a dispute. Many times, often not, I think the best way to actually get out of this legal complication will be in the resort to way of mediation. Many people do not actually do that. People feel that, no, you know, and that's where the complication begins, because I would want to do it in the country that I have originated from, and you may want to do it in the local country that you originate from Malaysia.
There you go. That's already
That's already a huge problem, because our laws are going to be different. So I think it helps how you actually say in your free trade agreement to put the laws governing. You know, which laws, if both of us have to agree which law is going to govern it.
A common law per se.
Yes. Is it going to be the laws of Malaysia or the laws of my country? For example, maybe I'm from like Denmark, you know.
Sure.
Or maybe we can then both go for an independent country. A lot of my clients have picked maybe like if Malaysia and maybe the UK, they've probably picked Singapore as the next seat if there's a dispute.
That's interesting. And what would be the advantages of that, Kokila?
Because I think when it's advantages of a country which is not
neutral,
yeah. So that way you'll be able to actually give both parties a fair trade, and no one will be able to complain, you know, because the appeal laws in your country may be different from mine. And generally, I think the laws in each country are very, sometimes very different from each other. I would personally say yes, but I will still ask you to mediate it first. So there are some companies and some agreements where they say the first right of dispute would be to resort to mediation or arbitration, which is, you know, and then only the last resort, then you go to the courts.
So basically, you want to go through those processes rather than, you know, going into litigation itself. And in your experience, just as a time frame, how long do such cases, particularly concerning FTAs, etc., take from start to finish?
Are you talking about the ones in courts or the one in
Yes,
mediation?
the ones in courts and also the ones in
It could take, I mean, now the courts are moving quite fast, but it could take to up to 2 years minimum or a year, which I think in terms of businesses, especially when it, like over the sea, you know, it may not be the best place for you to keep coming back to sort this problem out. So that is why I think mediation or any form of alternative dispute resolutions would be the best when it comes to FTAs or disputes out of FTAs.
Fantastic.
It's a win-win.
Thanks for bringing us up to speed with that. We'll take a quick break now. We'll be right back with Niaga Spotlight. Don't go anywhere. Welcome back to Niaga Spotlight. Still with me, Tamina Kausji, and today, of course, on the show, we are discussing legal updates and enterprise impacts with Kokila Vaani Vadiveloo in the house with us. So, Kokila, moving on now to another big chunk, which is very interesting, particularly for employers as well as employees all around Malaysia. There have been some updates to the Employment Law, the Employment Act 1995, as well as Industrial Relations Act 1967. Let's look at one of the most hotly contested issues as well that has brought about a lot of interest from different parties, which is the increase in paternity leave in Peninsula from 3 days to a mandated 7 days now. What can employees do to ensure they receive this actually?
I think it's open communication. You know, you actually have to, it is really, really important that, you know, both parents, especially the paternity leave, 3 days is not enough. I think I welcome this decision, but maybe because I am a female, so I think we could all do with an extra help back at home. But I think this is something that you must have an open communication, keep making sure the HR has spoken, I mean, you've spoken to the HR, because many of the problems here is the lack of communication between the employee and the paternity leave. So many of them are actually not in favor of this, but I think it is all, a lot of companies are actually realizing that if you speak to the open communication with your HR. This has been, I know a few companies that have advised which actually have taken this very well, you know, but it starts off with you must actually go in and speak to them. I think they're having a lot of trainings to see why 3 to 7 days and how they're coping with it.
How is beneficial?
How is it beneficial?
Sure.
Because 3 days is actually maybe a bit of a too short of a time because, you know, 1 week may be a better idea as well. And this is, of course, in line with the fact that the maternity leave has also increased substantially.
Right. From 60 days to 98 days
That's
now.
right.
Yeah, across all of Peninsula at least.
That's right, that's right. I personally had to give a few of my female staffs this updated maternity leave, and how it worked out. I think it's actually okay initially, you know, because there's
an adjustment period.
It
right?
is. Yeah. I mean, I'm not going to lie, and I think a lot of companies were going through that as well. But but I think the approach was actually to just realize that you are actually now becoming you're standardizing with all the employment standards overseas, you know, and I think that's what Malaysia should be looking forward, because it's always been 98 days overseas, you know, in the international standards. So we feel that Malaysia was actually lacking, but right now we're coming to par with it. So from 60 to 98 days, and I think this may have given some discrimination to the female employees, I know.
Yes, that's right. There are certain chambers of commerce, etc., that have already gone on the record saying that they are already hiring more men rather than women, looking at the burden, as they say, of maternity leave. So let's try and reframe that a little bit from both the legal standpoint, because when it comes to also the current Madani government's proposal to increase women's labour force participation rate. So it's actually very much more helpful. You're only able to have more women in the workforce from 55.8% to a target 60% if all such issues are made easier, right? What are the legal rights of the employees in case you're denied either your 7 days or your 98 days?
Oh, you can actually bring them to the labour courts and even to the civil courts for compensation. And I hope the employers know this, because they need to know their rights. I think a lot of companies have started actually giving trainings once they are inside the company to know that what are their rights and what are the thing. And if you look at it, I think recently I know a female employee who's 4 months pregnant who actually just got a job. So it's not really that bad as what I know. There's like at least
a lot of bad press
around it, but I do not think that is the real trend at the ground level, because when I spoke to this particular person, she's 4 months pregnant and she just got a new job. And I think the employee was very nice about it. The employer was very nice about it, and actually given her saying, we understand, and but this is how it is. So employers need to understand that they will be brought to court if you do not give the rights of the employees.
Correct. And at the same time, also looking at the much broader perspective of if we want to encourage a sustainable workforce for the future, of course, you have to be able to support parents today having children. Okay, so from there, Kokila, I'd also like to move into another issue, which is by 28th of March this year, we also have brand new several provision of Malaysia's first ever Anti-Sexual Harassment Act coming into effect. So under the mandates which are already enforced, what are the areas of responsibility when it comes to employers for actually providing a safe workplace for women as well as for men, of course?
I think it all boils down to policy and guidelines. And you have, many of them have not implemented this. Previously, there was this code of sexual harassment and that was only done by very few companies, and it wasn't even a mandatory thing. However, with this act, now it's mandatory. Every company make sure they have a certain definite policy and guidelines on how they're going to be conducting a sexual harassment case if it ever arises in the company. Of course, a lot of awareness trainings must be given, and I think it is also important to include it at your starter pack. When you join the company, you must...
Like a little book of rights.
That's right, that's right. You must be able to know that, this is what we're going to do, and policy guidelines, and also I think there should be a course, a short course, when you actually walk into the company to know that this is any company, that this is the anti-sexual harassment bill, and it should be, for me, if you ask me, it should be in a clause in your employment contract or your letter of offer. Because it is a very big thing.
Exactly.
It's something
and it's also, I think it goes into the wider perspective of building a respectful workplace culture.
That is right, that is right. You would want your employees to walk into a safe working environment, where you know that the laws have been protected. Many a times, you feel that, is the law really protecting the victim? It's come to that. Or is it also protecting, maybe the perpetrator, just because there's no correct, definite system. I think, therefore, there needs to be, if you're going to have a policy and guidelines, it needs to also spell out exactly how is the procedures going to be carried out.
That's
and
right.
And everyone, the employees and the employers, both, including the HR, need to all know and everybody on the same page. I think that is the most crucial thing about this latest Anti-Sexual Harassment Act 2022, because there's going to be tribunal. And I think is something, this is my personal opinion.
Sure.
I think the companies, when they are actually faced with this kind of complaints, they should have an external person just sitting in there to be able to just see what is going on. Because sometimes when you work with that colleague for such a long time, you may have a biased opinion about a certain person.
Or natural, conscious or unconscious one.
Yeah,
Absolutely.
that's right.
Great.
Yeah.
Fantastic. So from there, Kokila, looking at also some other amendments that have come about that especially affect enterprises and entrepreneurs and small businesses, the Insolvency Amendment bill was also passed mid of this year, and it aims to actually streamline the processes for administering bankruptcy. Can you tell us about what are some of the key areas of interest and how they're going to be affecting us?
This is actually very, very interesting, because I think the latest amendment was on 6th of October last month.
Yes, exactly.
That's right. So I think, first of all, applaud the government, because we must understand the less bankrupts there are, the better it is for the economy, because then a lot more people will be able to actually get a job. You know, in terms of getting accessibility to get a job, then it actually boosts the economy as well. Now, the first set of amendments was, I think there are a few amendments that have been pertinent in the Insolvency Act. Automatic discharge was one of them, you know, and I think the latest one has given you two different categories. They've added two categories, and it's very, very good because
quite comprehensive, yeah?
Yeah. So these two categories, if you look at it, was that if you are 30 and above, okay, because usually everyone goes like, you know what, why do I even bother? Because I'm not going to qualify for this automatic discharge. So initially they started with 50,000 and below. Because many, if you looked at it, there were many people who were just becoming a judge bankrupt because of the credit card.
Correct, debt.
You know, or like hire purchase when they buy a car. So, so what happened was the First Amendment was anybody below 50,000, I mean, a bankrupt or judged at 50,000 could apply for this. Then you came to this 6th of October recent amendments where two more categories were introduced. The two categories were if you're above 30 and, you know, COVID has affected us in many ways and mental health is one of them. So what has happened is, in short, they say if you're 30 and above and you're judged bankrupt, you go and meet a psychiatrist. And if the psychiatrist says that, yes, you do have some mental issues or you are not well, what happens is you bring the certificate and you go and apply to the Director General of Insolvency to get an automatic discharge. Not many people know about it. This is the very crucial amendment. So many was disheartened and they said, oh, I don't come under the 50,000 category, so I'm going to just have to be a bankrupt. But with this latest two amendments, and then they say, oh, maybe I'm too young. So the second category, if you're 70 and above.
I see.
Yeah.
So I think it's also being extremely humane in looking at what the different challenges are across the life cycle.
And I think that is exactly what a Bankruptcy Act should be, because it affects your status, as your solvent status in the country. So
very good to know about that.
Very, very good. It was very heartwarming, to be honest.
All right, awesome. So Kokila, as we're looking at rounding out the discussion, I do want to focus a little bit on, before we close, laws pertaining to ESG in Malaysia. So ESG, of course, is the biggest catchphrase and really has been. I think ever since, of course, the pandemic brought us all to so much more realizations as business communities about the need for sustainability and minimizing environmental impact, with, of course, continuing to make business profits. So what are some of the pertinent laws that actually impact businesses operating in Malaysia right now?
I think there are three acts: the Environmental Quality Act and its respective amendment in 2007 and 2012. So they've been obviously moving towards ESG with the international standards constantly, I think. I think the environmental sense, if you look at businesses today, you would see go green, go paperless, you know, and in fact, some of them you actually get like a discount or a 2 ringgit off if you bring your own tumbler from home. You know, these are the little things that I think businesses have moved forward. And sustainability, I think, but unfortunately, I'm not sure whether this only extends to medium size and big.
Right.
You know, I do not see it being applied at the small, medium enterprises, businesses. There are one or two, but I think the awareness there are still a little bit on the low side, if you ask me. I think we should probably create this awareness to say and bring up more lucrative grants for ESG-based businesses in terms of social, in terms of environmental, to say, look, it is at the end of the day for us. So let's do a clean, you know, trade business in terms of ESG standards.
Exactly. And I think you make a very good point there about the SMEs as well, and perhaps them needing a little bit more time to adjust themselves. Kokila, this has been such a pleasure having you on Niaga Spotlight. Thank you so much for your time and insights.
Thank you, Tamina. Thank you.
Fantastic. So, well, that's all we have time for today. We'll, of course, be back next week with more business analysis and insights. Meanwhile, here's to a productive week ahead.